Starting this October 2025, some significant and rather concerning changes to the USCIS rules are officially taking effect. If you're an immigrant, a visa applicant, or someone navigating the complex U.S. immigration system, this news directly impacts you. These rule changes have the potential to affect everything from how your applications are processed to the eligibility criteria for certain benefits. It's essential to understand what's changing, why these changes matter, and most importantly, what you can do to protect yourself and your immigration status. Whether you're applying for a green card, work authorization, or other immigration benefits, this video will break down everything you need to know about the USCIS rule changes coming this October. First, let's talk about the big picture. The United States Citizenship and Immigration Services, or USCIS, is the federal agency responsible for overseeing lawful immigration to the United States. They process millions of applications every year, everything from citizenship applications, family-based green cards, work permits, asylum claims, and more. Given the sheer volume, USCIS regularly updates policies, fee structures, and procedural rules to manage the system and try to maintain efficiency. But the upcoming rule changes this October are more than just routine updates. They include stricter eligibility requirements, changes in application fees, new documentation standards, and expanded discretionary powers for immigration officers. These adjustments have been met with concern by many immigration advocates, lawyers, and applicants because they could delay approvals, increase costs, and make the process more challenging for many. One of the most notable changes involves stricter evidence requirements. Previously, USCIS accepted a wide range of supporting documents to prove eligibility or meet legal standards for immigration benefits. Starting October 2025, applicants will face more rigorous scrutiny over their documentation. This means the agency may request more detailed proof of things like financial stability, relationship authenticity, employment status, or even continuous residence in the U.S. If you're applying for a family-based green card, for example, the bar for proving a genuine marriage might become higher. For work visas, employers will need to provide more comprehensive evidence about the job role and the applicant's qualifications. Why does this matter? Because failure to provide precise and comprehensive documentation could lead to increased requests for evidence, RFEs, which cause delays and sometimes even denials. An RFE is when USCIS asks for additional proof before making a decision on your case. They're not new, but under these rules, the threshold for what counts as acceptable evidence is rising. That means you'll need to be more thorough and prepared than ever before. Alongside evidence requirements, USCIS is also expanding its discretionary powers. Immigration officers will have more latitude to deny applications based on public charge considerations, criminal records, or security concerns. The term public charge refers to whether an applicant is likely to rely on government benefits for their support. While public charge rules have existed before, the new policies widen the scope of factors considered. This means that applicants with limited income or certain health conditions could face increased scrutiny or denials. Another significant update concerns application fees. USCIS announced fee increases effective October 1, 2025. The average cost for many immigration applications, including green cards and naturalization, will go up by up to 20%. For families filing multiple applications, these fee hikes can add up quickly, making immigration an even bigger financial burden. Some exceptions and fee waivers remain in place for low-income applicants, but those are narrower under the new rules. Additionally, the new rules will impact the process for work authorization documents, commonly known as EADs or employment permits. USCIS will impose tighter restrictions on the duration and renewal eligibility for EADs. This could mean shorter validity periods and more frequent renewals, creating uncertainty for visa holders relying on these documents for employment. Delays in processing times are also expected, given the added documentation requirements. Let's also discuss the impact on asylum seekers. The rule changes introduce new criteria for asylum eligibility and admissibility. For example, applicants will need to provide more detailed evidence to prove a credible fear of persecution, and officers will have greater discretion to deny cases based on minor procedural errors or inconsistencies. This may lead to longer waiting times, higher denial rates, and increased legal challenges for those seeking refuge in the U.S. So what should you do to prepare for these USCIS rule changes? The first step is to educate yourself thoroughly about the new requirements. If you have an application currently pending, check the USCIS website regularly for updates on how these rules might affect your case. Consider consulting with an immigration attorney who is up to date on the latest policies. They can help you understand if your application needs to be amended or supplemented with additional evidence. If you're planning to apply for any immigration benefits in the near future, start gathering comprehensive documentation now. Don't wait until the last minute. Make sure your paperwork is organized, accurate, and includes everything USCIS might request. For family-based petitions, collect joint financial documents, photos, and affidavits that demonstrate the authenticity of your relationship. For employment-based cases, secure detailed job descriptions, contracts, pay stubs, and letters from employers. It's also vital to be aware of any changes in fee structures and budget accordingly. The increased fees can be a shock if you're unprepared. Check if you qualify for fee waivers or reductions based on income, but be aware these are limited and subject to stricter standards. If you rely on work authorization, keep a close eye on expiration dates and submit renewal applications as early as allowed to avoid gaps in your ability to work legally. And if you are an asylum seeker, work closely with a legal representative to ensure your case meets the new evidentiary standards and that your filings are thorough. One more important point: be patient. With these rule changes, USCIS processing times are expected to increase significantly. Don't be discouraged if your application takes longer than usual. Delays are likely to become the new normal. Use this time wisely to gather any additional documentation and stay in close contact with your legal counsel. It's also worth mentioning that these changes are being challenged by some immigration advocacy groups and legal experts who argue that they make immigration unnecessarily harder and may cause harm to vulnerable populations. There are ongoing court cases and potential policy revisions that might affect how these rules are applied, so stay informed on the latest developments. Finally, if you have questions or concerns about your immigration status, don't hesitate to reach out to trusted sources. This includes licensed immigration attorneys, non-profit legal aid organizations, and official government resources. Avoid relying on social media rumors or unverified information, as immigration law is complex and mistakes can be costly. To recap, the USCIS rule changes taking effect this October represent a significant shift in the U.S. immigration landscape. From stricter evidence requirements and expanded discretionary powers to higher fees and shorter work authorizations, these changes are likely to make the immigration process more challenging. But by preparing now, understanding the new rules, and seeking expert advice, you can navigate this evolving system more confidently.